Welcome to Easy Learning.
Exercise number 7. It is evident, therefore, that the rationale for awarding costs is adequate indemnity for the expenditure incurred. In other words, there can be cases where the cost may exceed the claim calculated over a period of time. In such instances, unless real costs are awarded, not only is victory Pyrrhic, but also the ultimate outcome is also injustice. Section 35 of the Commercial Codes Act enacts that while awarding cost, the general rule is that the unsuccessful party should be directed to pay cost to the successful party. Interestingly, Parliament also envisioned payment of cost in respect of partial success of claims. It also contemplated the direction to pay cost at different stages or for different steps in the proceedings. Thus, one of the obvious and apparent objects of amending the law relating to commercial claims and the procedure to be adopted was to ensure that successful parties secured reimbursement for the cost they incurred. At the same time, the court was clothed with an overall discretion. This important step was preceded by the Law Commission's report on cost in civil litigation. Therefore, the imposition of cost or even real cost cannot be an event too late in the legal system. It was mandated by the legislation through enabling conditions to cater to a long standing and sorely felt need. This court is also of the opinion that the retention of discretion with the court by section 35 within bracket 1 and 35 within bracket 2 is an important feature because there may be cases where one party or another engages counsels or avails legal assistance which is commensurate to its status or financial standing, which might not be matched by the other party or may be incommensurate with the nature of the litigation. The disparity in financial standing of the parties in such cases, in the event the more affluent or rich party succeeds, can lead to the ruination of the unsuccessful party, even though it might have had a credible defense that warranted a full trial. In the facts of this case, the approach and directions to pay cost made to the plaintiff cannot be termed unreasonable. Hearings took over a long span of time. The defendants had to engage and avail of counsel's services and labored under interim orders. Given these circumstances, the costs imposed are neither unreasonable nor disproportionate. For the above reasons, this court holds that the appeals have to fail. However, the single judge shall ensure that all suits till then listed together shall now be listed together for further proceedings. The defendant's contentions in respect of the ad interim injunctions and whether they are to be confirmed during pendency of shape, trademark, passing of suits of the plaintiff as well as plaintiff's arguments for interim injunction in the passing of claim in the composite suits shall be taken up together and decided by the single judge. The rights of parties are kept open with regard to respective contentions in that regard. The appeals are hereby accordingly dismissed without order on cost. Full stop.